The National Prosecuting Authority has been handed a lifeline by the Supreme Court of Appeal to correct its wrongs in its first ever state capture case, the R1 million Nulane Fraud matter. Now, this after the Supreme Court of Appeal, in a judgment today, granted the NPA leave to appeal the 2023 judgment of Acting Judge Gusha, which discharged the Gupta-linked accused in terms of Section 174 of the Criminal Procedure Act. The SCA found, among other things, that the High Court committed numerous errors of law and subsequently ordered that the respondents may be retired for the same offences in respect of which they were acquitted by the Free State High Court on the 21st of April 2023, as if they had not previously been arraigned, tried and acquitted, provided that a different judge shall preside over the trial. Advocate Mthunzi Mhaga, NPA spokesperson, joins me now. Good afternoon and thank you for joining us. So the NPA has been given a second chance.
In essence, let me first thank you, SABC, for always giving us a platform to come and communicate our progressive work. It doesn't go unnoticed. We really appreciate that. Secondly, this is a confidence booster for our prosecutors who have been vilified unfairly so, because this had been branded as a failure of the NPA in circumstances where we've made it clear that it is an isolated setback of which we did not agree with Honorable Acting Judge Gusha. And therefore, it now paves a way for us to reinstate the charges before a different judge. And you'll recall that currently we're under siege, so-called, because of people that you call legal analysts, who I regard as legal commentators, because they adopt a very dangerous approach of viewing legal issues from an uninformed, emotional and political perspective without applying their minds to the judgments. Some of them comment and make a formidable view without even reading judgments. We've made it clear that we have made progressive work insofar as the state capture related cases are concerned. This to us is a demonstration of our prosecutorial prowess, our prosecutorial arsenal and machinery, and the capacity to prosecute effectively complex state capture related corruption cases. I know that the accused have not yet been found guilty, but this to us is a clear demonstration of the fact that our long-held view that we committed no error or comedy of error, as Acting Judge Gusha said during trial, but we did all that we had in our power to ensure that we present a formidable case that warranted an answer on the part of the accused. Fortunately for us, the SCA has vindicated us, because they say she directed herself in applying the legal principles applicable for an application in a discharge at the close of a state case, even as far as the application of law insofar as accomplice witness of a 204 in terms of Section 204 of the Criminal Procedure Act. So it's a lifeline indeed.
So you're saying it wasn't, the case wasn't bungled?
It was not.
So then how's the whole thing actually been bungled?
The SCA has articulated clearly that the Honorable Judge was erratic in applying the law.
All right.
Which means the fact that she had said it was a comedy of errors, she was clearly wrong. This is the appeal court that has found her judgment to be wrong and has ordered a retrial before a different judge. We now have to go back and rearrange ourselves and prepare for facilitating a re-enrollment of the case.
Now, what did the High Court identify as errors in law in their judgment?
What the High Court had done was to say there was not enough evidence for the accused to respond to the charges. And therefore, in terms of Sections 174 of the Criminal Procedure Act, the test is, would a reasonable court, carefully considering the evidence and convicting the circumstances, and therefore, does the evidence presented so far call for an answer on the part of the accused? That is, can they move to the witness box and present their side of the story? The Honorable Acting Judge has said, no, we have not done enough. And we said, no, we will invoke Section 319 of the Criminal Procedure Act and prove you, Honorable Judge, wrong. And in this instance, we have done. And remember, Juliet, it is not the first time that we've got the SCA ruling in our favor in similar circumstances. The Honorable Judge Hlophe also got it wrong on the former Minister of State Security, Minister Bongo. And they ordered a retrial of that case. It has since been enrolled, and we are also of the view that we'll sustain those charges. So we are steadfast in exploring the rule book, in exploring the commentary in the Criminal Procedure Act to say we will use it in deserving cases, and we have just started. You have not seen nothing, but you will see a prosecutorial machinery in action. And let me remind you that currently on state capture-related cases, we are sitting at cases enrolled 50, 133 investigations declared, and our asset forfeiture strategic tool is yielding the desired result in injecting a lot of money into the fiscus of the state, because currently we're sitting at 14.2 billion in freezing orders obtained by the AFU working with the IDEC. We have deposited into the criminal asset recovery account an amount of 18.2 billion. We've been under siege, but we are getting it right. We need to be applauded and we need to be supported. And we are glad that the judges have seen through that in some of these cases we are being unfairly treated.
How confident are you that you will get a conviction this time around?
We have not failed. So when you say this time around, it gives an impression that we had failed. We had not. The judges are with us.
Right.
After careful examination and interrogating and assessment of available evidence, prosecutors took and still take a firm view that the charges preferred against the accused can be sustained. They held that view during trial, they hold that view today. And we're confident that we'll present a formidable case that will result in the conviction of all the accused once we facilitate the re-enrollment of the matter.
And when does this kick off again?
Currently, we are in the process of studying the 57-page judgment. We still have evidence. Our investigators and the prosecution team are going to rally around and work tirelessly 24 hours to ensure that within a reasonable time the matter is reinstated.
Appreciate you coming in today. Thanks very much, and for also setting the record straight on some of those matters.